Good morning, students. This is Sreekanth, Assistant Professor, Dr. Ambedkar Global Law Institute, Tirupati. Right? So, till now, what we have learned, we know the meaning of the company, characteristics or advantages of incorporating a company. Once a company has been registered, it acquired status of a legal entity separate from its members. That means company is different, members are different, and there is a curtain drawn between the company and members. It is known as corporate veil. So courts will always think that company is different, members are different. They never interfere in the internal management of the company. However, in certain circumstances, courts disregard the corporate veil and look behind the personalities. We have seen judicial interpretations, statutory provisions. Now, after preparing the memorandum of association and articles of association, what you are going to do? You are going to the registrar of companies and filing the same with the registrar of companies. Right. Now you have prepared memorandum of association, articles of association, and different things. Yesterday we have seen what it is. We have to prepare memorandum of association, articles of association, an agreement to be entered into with a person who is likely to be appointed as a managing director, whole time director, or manager, and a declaration that all the requirements of the Companies Act have been complied with, signed by the requisite persons, a written consent of the directors to act as director of the company, a written undertaking by the directors to pay for qualification shares. If you want to be a director in company, you have to do two things. One, you should have director identification number. It is also known as DIN, DIN, director identification number. Second one is you have to take qualification shares in a company, at least one share. So if you don't take shares, you are unqualified or disqualified to be a director, and a list of persons who have agreed to become the first directors of the company. So you have prepared all these documents and you have submitted to whom? Registrar of companies. Right. Now once the registrar of company has satisfied himself that company is proposed to be formed for lawful object, memorandum of association is in order, articles of association is in order, then statutory declaration is there, name of the company is acceptable, then he will issue one certificate. It is known as certificate of incorporation. After getting all these documents filed with the registrar of companies, you will get this certificate of incorporation. Now once the certificate of incorporation has been given to you, it presupposes that company has come into legal existence. For example, baby was born. Once baby was born, birth certificate was given. That means from the date that has been mentioned in the birth certificate, baby has come into this world. Likewise, for the company, a certificate of incorporation is very, very important. Unless and until you get the certificate of incorporation, you cannot start doing the business of the company. In fact, the Companies Act prescribes two certificates. One is certificate of incorporation, another one is certificate of commencement of business. Normally, a private company can immediately start its business after getting certificate of incorporation, but a public company, even after getting certificate of incorporation, it has to obtain a further certificate known as certificate to commence the business. However, such a certificate is not necessary for a public company which has no share capital. So, once the certificate of incorporation has been given by the registrar, remember the company has come into existence from the date on which it has come into existence. So, yesterday we have seen one case law, Jubilee Cotton Mills versus Louis. What happens in this? The necessary documents for the registration of the company were delivered to the Registrar of Companies on 6th January. 6th January, the company has submitted Memorandum of Association and Articles of Association. After 2 days, that is on 8th January, the registrar issued a certificate of incorporation, but he has put the date 6th January. Remember, certificate was issued on 8th January, but dated is 6th January. The date mentioned in the certificate of incorporation is the conclusive proof. Remember, so on 6th January, that is before the certificate of incorporation was actually issued, the company made allotment of shares. Unless and until company comes into existence, you cannot allot the shares. Here, on 6th January, the certificate has been issued, dated 6th January, even though issued on 8th January. That means from the 6th January itself, the company has come into existence. So on 6th January, that is, before the certificate of incorporation was actually issued, which was on 8th January, the company made an allotment of the shares. Now, you cannot allot shares unless and until company comes into existence. That is the rule. The question arose about the validity of the allotment as it was made before the issue of certificate of incorporation. So, some persons raised a question that allotment of shares is void. Why? The company has not come into existence. It was held that allotment of shares was valid as in law. The company was formed on 6th January. Even though it has been issued on 8th January, it is dated as 6th January. The reason for the same is that certificate of incorporation is conclusive evidence for everything that has been contained in that certification. Right? The certificate of incorporation is conclusive on the following points. The certificate of incorporation is conclusive on the following points. First one is that all the preconditions means legal requirements of registration have been complied with. Legal requirements means whatever that has been said in the Companies Act 2013, you have to follow. Everything that has been prescribed under 2013 Act, you have to follow. So that all the preconditions or legal requirements have been complied with. Second one is that the company is properly registered. So properly registered by submitting all the requisite documents. Third one is that the company came into existence on the date of certificate of incorporation. Now you got certificate of incorporation. Now you can start the business. You can allot the shares, issue shares, debentures, everything you can issue. Why? The company has come into existence. It has a separate legal entity. Unless and until you don't get the certificate of incorporation, you cannot carry on the business. You cannot issue shares, debentures. You cannot accept deposits from the public. You cannot do anything unless and until you acquire this certificate of incorporation. It is the birth certificate for the company. Yes, students, now you understood the meaning and importance of certificate of incorporation. You got the certificate of incorporation, the company comes into existence. Yes, you can start the business, you can issue shares, you can issue debentures, then what not, You can issue, you can do whatever that has been said under the Companies Act 2013. Now, let us go into another important concept which is known as promoters or company promoters. This is very important from your examination point of view. Many questions, many times a question has been asked on the promoters. Now, who will form the company? Who will form the company? Normally, before company comes into existence, there are certain persons who think of forming a company and actually brings the company into existence. For example, I am there, I want to start a company. So what I will do? I will acquire land, I will acquire plant and machinery, I will prepare memorandum of association, I will prepare articles of association. In case of public company, 7 members should be there minimum. In case of private company, minimum 2 persons should be there. They will sign the declaration. I will enter into contracts with the outsiders for what? For establishing a company. I want plant and machinery. I will order plant and machinery. I will go for technology transfer, whatever it may be. So I will do whatever to bring the company into existence. Now, whom am I? I am a promoter. So I will do all these sort of things before the company comes into existence. In fact, old act promoter, the term promoter has not been defined, but in this new act, the concept of promoter has been defined, that a promoter is a person who originates the idea of starting a business. First, he will think of starting a business, then plans the formation of a company, and actually brings it into existence. He will enter into so many contracts, then he will enter into contract for procuring raw materials, land and machinery, plant and machinery, everything. He will do all the preliminary work incidental to the company. So he will do all the work. In simple words, a promoter is a person who brings a company into existence. Now, to determine whether that person is a promoter or not is a question of fact in each case. So, this depends upon the nature of the role played by him in the promotion of the company. Now, it is not necessary that promoter should be an individual. A firm, an association, or company may also act as a promoter. A partnership firm may act as a promoter, an association or a company may also act as a promoter. The only basic requirement is that they should take necessary steps in the formation of a company. Remember, however, everyone who is connected with the formation of a company may not be a promoter. For example, advocate is there. He will do all the legal work before the company comes into existence, but he is doing in a professional capacity. He cannot be called as a promoter. Solicitor means lawyer who prepares the documents of the proposed company on behalf of the promoter. He is not a promoter. Why? He is doing the same in the capacity of a professional. And chartered accountant is there, and chartered engineer is there, valuer is there, who helps the promotion in his professional capacity, is not a promoter. So, such a person may become a promoter when, if he helps in the formation of the company by doing an act outside the scope of his professional duty. If you are acting in a professional capacity and you are giving your professional advice to make the company comes into existence, you cannot called as a promoter. A chartered accountant, he will assist the promoter. Valuer will be there, an engineer will be there, advocates will be there. They will prepare all these type of documents for what? To register with the registrar of companies. Why? Memorandum of association, it should be in compliance with Companies Act. Articles of association, it should be in compliance with Companies Act, or you can adopt table F. So everything should be according to legal sanctity. So they will help you, but they cannot be called as a promoter. So, in fact, promoters occupy important position and they have very wide powers relating to the formation of the company. So now you got to understand the meaning of the term promoter. Promoter means a person who thinks of forming a company and actually brings the company into existence. He will do all the necessary works for bringing the company into existence. Now, the promoter is there, he has incorporated the company. Now, what happens after incorporation? What is the position of the promoter before incorporation and after incorporation? This we can tell it in another meaning, legal status or position of the promoters. Now, we know that promoters are responsible for the formation of a company. They bring the company into existence, right? As such, the promoters occupy important position and they have very wide powers relating to the formation of the company. So, legal status of a promoter is concerned, he is neither an agent nor a trustee of the proposed company. Why? He is not the agent because there is no principle in existence. You have read the same in law of agency in contracts too. Principal, agent will be there. There is no principle. When there is no principle, there is no agent. So he is not the agent. He himself is the principal. He himself is the agent. So he is not the agent because there is no principal existence. And he is not the trustee because there is no trust in existence. Again, law of trust. However, it does not mean that promoter does not have any legal relationship with the proposed company. So what happens is he stands in a fiduciary relationship towards the company which he brings into existence. Fiduciary means pertaining to money. Now, whatever promoter can sell his property to the company, so he stands in a fiduciary relationship that is pertaining to money. That means he has to disclose fully all the material facts relating to the formation of the company. His dealings with the company must be open and fair. Now, what happens is they stand undoubtedly in a fiduciary position. They have the powers of defining how, when, and in what shape and on what supervision the company shall start into existence and begin to act as a trading corporation. So, these are the persons who form the idea of forming of the company. They investigate the idea. So, different functions will be there. Tomorrow, we are going to deal with different functions of the promoters. Yes, students, got something today? This is Sreekanth signing off. Have a good day, children.